Thank you, Mr. Chairman. I hope that as we're going through the language in other bills, if we decide to adopt any additional policy, if we find a word or two that we think ought to be different, or policy that ought to be different, that we'll all feel free to suggest an alternative that maybe we can find some agreement on it. That's part of the conference committee process.
Absolutely.
Mr. Chairman, I wanted just to clear up one thing that I believe it was Mr. Gosh, who spoke initially, identified as a concern with regard to a respondent being given as little as 12 hours notice before appearing at a hearing. What Mr. Gosh did not say is that if a person gets a notice for a hearing any closer to the hearing than 5 days before the hearing, the person has a right to ask for a continuance of at least 5 days in order to prepare for the hearing. So no one, and that's in the bill, line 231.27. So no one would be faced with only 12 hours to prepare for a hearing unless they chose to do so. But they'd have a right to a 5-day continuance to prepare. I want to note that the standard of proof in this bill, the preponderance of evidence, which he indicated was low, it is the standard of proof in civil law in Minnesota for proving millions of dollars of hundreds of millions of dollars of liability in business disputes or claims against defendants. It's our standard. Again, we could have a discussion about whether it's the appropriate standard in these circumstances, but it's not unusual at all. I think it's more than adequate standard under the circumstances. I would note that there was a concern about if there was an order issued, there were only 24 hours to turn in the firearms. The language in the bill actually says, he said it could be ordered to be as quickly as 1 hour, and that's also not in the bill. The language for the order is contained in the bill. Essentially, it says, I think as soon as reasonably possible, and in any case, no later than 24 hours. So no one's going to be required to turn in your firearms immediately unless, and there is a provision in the bill where a judge could determine that there is an immediate danger of bodily harm. Even if it's not one of the ex parte orders, but they have the hearing after the regular notice, and the judge looks at the situation and says, well, there really is now an immediate danger of bodily harm, and we need to move right away to get the firearms out of the house, and then the judge could issue a warrant for the removal of those firearms immediately by law enforcement. I wanted to, in addition to what I think are very compelling statistics that Representative Richardson gave to us, Montgomery County, Maryland, recently completed their first 3 months of experience under their red flag law in October, November, December of 2018. They also, they had 201 petitions in Montgomery County, Maryland, and the court only granted 148 of them, which suggests to me that in addition, and they also allowed individual persons to file petitions. We very explicitly decided not to do that because of the concern that was raised by, among others, gun rights individuals that a vindictive spouse or a neighbor could file stuff for harassment purposes. But this also tells me that the courts are also screening these petitions carefully, and they're not automatically assuming that whatever shows up in the petition is enough to meet the legal standards for issuing the petition, even if the petition is only coming from law enforcement agencies or from county attorneys. Senator Limmer made reference to what information, or asked the question, what information would be relied upon by the court in making this decision. And I would turn the members' attention to line 232.21, where it starts a pretty substantial list of items that the court could use in determining whether an order is appropriate, including the history of threats or acts of violence directed toward another person, the history of use, attempted use or threatened use of physical force by the respondent against another person, violations of court orders, including but not limited to, orders listed under these chapters here, or Chapter 260C or 518B, where you're getting into the orders for protection and so on. Prior arrest for felony offenses, violent misdemeanor offenses, stalking offenses, domestic assaults, convictions for the offense of cruelty to animals, which is a very strong indicator of a person's propensity to commit violent acts toward people. A history of self-harm by the respondent, whether they're named in an existing order, such as here, or an OFP, or an HRO. So these are the kinds of factors that courts will use to determine, and we want them to be thinking about these things because they are indications that a person has some history and demonstrate a risk of harm or committing harm to others. Senator Limmer also raised the question of what if a person yells at the kids who are running across the yard, if you do this again, I'm going to kill you, you brats. Well, that's already a felony offense. That's terroristic threats, or what we have renamed as threats of violence under existing state statute. It doesn't always get charged out. Sometimes it's dismissed as hyperbole, but sometimes it's not, and that's sort of a charging discretion. But it already is a felony offense to do that. There's also a concern raised about notice here, and I want to turn people's attention to line 235.14, where actually this is the point that I already made earlier, the reasonably practicable or no case later than 24 hours in terms of notice to turn in firearms. I would note that, there was some concern raised about law enforcement and whether they're comfortable retrieving firearms under these circumstances, and that's been addressed in a lot of situations, but I just want to add, it's already law enforcement's responsibility in the case of firearms orders that flow from domestic violence convictions to retrieve the firearms if the subject of the order doesn't voluntarily turn them in. We already placed that responsibility on our law enforcement agencies, and they're the only people who are trained in our society to accomplish that, so they're the best set to do that. I would also add that there's nothing in this bill that requires any local law enforcement agency to utilize any of these mechanisms. A sheriff, for example, could simply decide that they're not comfortable with any of this and that they are, as a matter of policy, not going to file any of these petitions with the district court asking for the relief. On the other hand, there might be that one or two situations where they say, boy, we really do want to use this tool this time because we don't have any other basis for separating the firearms from the dangerous person. And at that point, they'll be glad they've got the tool available in state law if they choose to use it. So those were my thoughts, members. Again, we have, this bill started out differently, and through the collaborative process, deliberative process, and receiving input from parties across the spectrum, law enforcement and advocates for victims and gun owners as well, because this is not the first time that this idea has come up. We made a number of modifications to this bill, and Representative Richardson and Representative Pinto and others who were involved in drafting this to come up with what we think is a really good, modest proposal with demonstrated history in other states of saving lives, and we'd encourage members to consider voting for it under those circumstances.